Alright, revocation of certification. Engineering Certification Reference Guide, Federal Railroad Administration, revised August 2000. Revocation of certification. Revocation of certification. Railroad acquiring with the convincing of the info with the engineer with the no longer meet for the qualification requirement shall revoke their certificate with an exemption voluntary referral policy. Revocation of certification because provided in 240-119E with the voluntary referral policy of the railroad certified or recertified as the person qualified locomotive engineer during the period of certification is valid. Acquire the information conveying instances for the railroad that the person no longer meet for the qualification requirements of Part 240 shall revoke with the person certificate qualified locomotive engineer. Revocation certification intervening caused by minimal nature of the railroad shall not invoke there as intervening causes which prevented the material impaired with the engineer's ability of the railroad may decide whether not to invoke the violation was by the minimal nature of the non-effective of the railroad's safety. Railroad should not determine the person available to meet the qualification requirement of Part 240 shall note the revoke of the person's certification provided in 240-307 and A with the sufficient of evidence of the existence of the established intervening cause that prevented the material impaired with the locomotive engineer's ability to comply with the railroad operating rules and practices. With constitutional violation of 240-117E1 through E5, a railroad may determine the person meets the qualification requirements of 240 decided not to revoke the person's certification provided in 240-307A. The sufficient evidence exists with established violation 240-117E through 5 of the ways to minimal nature of the no direct potential effect on the railroad safety. The FRA permits the railroad to have the discretion to determine whether revocation is desirable under these limited circumstances. Revocation certification intervening cause example the intervening cause trains being due to the defective equipment entering main track based on incorrect information from the conductor of the dispatcher. Examples of the intervening causes may be the failure to operate the train prescribed speed limit because of the defective equipment. Conductor dispatcher may lay incorrect information to engineer with a reasonable light on making the prohibited train and moving it. Revocation certification, minimal nature of the no effective of the safety. For example, the minimal nature of the front units of the seat of the train speed with the bottom of the seat of the grade with a high speed track of the range of the train speed is okay. Speed restriction, difficult train handling territory, flat switching, kit cars, snow plowing, operations, spotting cars and steep inclines. Except violation of the minimal nature by high speed track with the bottom of the sleep grade with the front of the lead unit with the 4 units consists of the following of the 100 cars enter speed, the restriction of the 10 miles over speed with the third unit balance. Train enter for the speed restriction of the proper speed, maintain with the speed with the remainder of the train, slowing down with the speed restrictions and located with the difficulty train handling territory, switching, kegging cars, snow plowing operations, certain industrial switching operations require short bursts of the speed to spot cars on steep bank inclines. Preamble to the 1999 final rule, the minimal nature applied would also require the sufficient evidence to be presented to prove that the violation did not either directly or potentially affect the rail safety, the defense of the content, certainly not apply with the violation of actually caused by the collision or injury that, given the factual circumstances surrounding the violation, could have resulted in the collision or injury. Revocation certification, minimal nature with no effective safety. It is covered the car could have caused a collision or injury, but it is not minimal. Passing a banner is not a minimal, but barely touching a banner could be minimal depending on the railroad use of its discretion. Preamble also see with the contract of the train fell short of the top of the banner while acting the single requiring of the completing shot before passing with the during an efficient test of the tracking of the banner may have no direct effect of the rail safety. The potential effect of the sense of the banner would be simulating rail car in another train. Meanwhile, there's a difference between passing a banner versus making an incidental touching of the banner. The locomotive of the train barely touches the banner. If so, the locomotive does not run over the banner, break over the banner, cover the banner to fall down. The incidental touching could be considered minimal nature violation does any of the direct potential effect of the rail safety. This because of these incidental touching is not likely to cause the damage to the injuries of the crew members, even if the banner was another train, although it was arguably with the banner where a person with a touching could be fatal. The FRA will be allowing railroads discretion to consider the type of the scenario in context, excluding violation pursuant to the minimal nature of the application. Revocation certification, minimal nature with no effect of the safety, with the extent of entering the main track with the Britain authority authority refers to correct train number, but incorrect locomotive number could be a minimal nature. Preamble to 1999 final rule. If the train has received the oral written authority to occupy the segment of the track, the oral authority refers to the correct train number. The oral authority refers to the wrong locomotive because of someone transposed the numbers of the engineer's violation, not changing this error before entering the track without proper authority, considered minimal nature, no direct potential effect on the rail safety, since the railroad would be aware of the whereabouts of the train. The accidental risk of the safety of the paperwork mistake may practically be zero. Under the same scenario, whether there are no other trains equipment operating within the designated limit, there may be no potential effect of the rail safety as with no direct effect. Revocation of certification intervening causes in minimal nature. Railroad must record evidence prior to suspension of the hearing. Oversight report of Class 1 and 2 with the 240, 215 records. Class 3 railroads must take the good faith determination after the reasonable inquiry. Railroad shall place relevant information on the records, maintain compliance with the 24309. Oversight for the Class 1, including the National Railroad Passenger Corporation. Class 2 railroads, 240, 215. Class 3 railroads, if the sufficient evidence meets with the criteria provided in 240, 307, intervening cause minimal nature because of the available either prior to the railroad's action, suspended certificate provided with the 24307 prior to the convening of the hearing provided in 24307. Provided with the railroad makes the good faith of the determination reasonable inquiry occurs of the conduct provided with the 24307 and appropriate the railroad which does not suspend the locomotive engineer certification as for the 24307A, the no violation 24307A. Revocation of certification upon receipt of the reliable information immediately will suspend the certificate prior to upon suspension provided with the notice of the reason pending revocation and opportunity for hearing oral confirmed in writing written notice of the collective bargaining agreement within 96 hours. Revocation of the certification continued pending a revocation determination. Railroad shall upon receipt reliable information indicating of the personal lack of the qualification part 240 immediately suspend with the person's certificate because the railroad cannot always make the determination immediately. Regulation cannot require the railroad prohibit the engineers operating train immediately after the occurrence of possible decertifiable event. So Von Eslin's letter prior to upon suspending person certificate provided with the notice of the reason for the suspension for the pending revocation opportunity for the hearing of the proceeding officer for the other than investigating officer for the notice of the initially given the either orally or in writing. Even if given orally, it will be confirmed in written. Written confirmation must be prompted with confirmation conformed to the notification provided provisions applicable. Collective bargaining agreement shall be deemed safe to satisfy with the written confirmation requirement of 24307. In the absence of the applicable, the collective bargaining agreement has a written confirmation must be made within 96 hours. 24307A-B. Alright, convening hearing of the 10 days if the collective bargaining agreement is determines no longer qualified basis for the conclusion imposed the appropriate period of revocation retain record for a hearing of 3 years. Conveying of the hearing of the deadline prescribed in the eve of the 24307 C Tet 1, 10 days of the day of the certificate suspended unless the locomotive engineer requires the consent of the delay and with the stating of the hearing of the applicable collective bargaining agreement is permitted with the 24307 D. Determine the record hearing whether the person no longer meets the qualification requirement of Part 240 stating the explicit of the base for the conclusion reached for the appropriate imposed for the pertinent period of the revocation 24117, 24119, and retain the records of hearing 3 years after the day of the decision is rendered. Revocation certification 24307. The hearing unless hearing waived with the collective bargaining agreement to conduct with the waive of the presiding officer for the investigating officer for the conducting hearing to achieve the problem of the failure determination testimony verbatim relevant prohibitive evidence received. Except for the provided 240-307 with the collective bargaining waive rights at 1 of the Bureau discretion, J with the 240-309 oversight report. A hearing required with the section be conducted in accordance with the following procedure. Hearing should be conveyed within days for the certificate suspended unless with the locomotive engineer required with the consent of the delay with the starting of the hearing. The hearing should be conducted with the presiding officer who can be within qualified authorized of the railroad other than an investigating officer. Presiding officer exercise of the power necessary to propagate with the conducting hearing purpose of achieving the prompt of the failed determination of all material issue for the controversy of the presiding officer convey with the presiding over the hearing. Testimony by witness of the hearing should be recorded verbatim and relevant and provided evidence should be received unless for the presiding officer to determine the evidence of the unduly repetitive, the extensive, lacking in relevance for the omission would have been fair, prompt, orderly, fair resolution of the proceeding. Proceeding officer may adopt the need for the procedure for the submission of the evidence writing, examine the witness of the hearing, convey with the recess adjourn, otherwise regulate in the course of the hearing to take the other adverse authorized action, expedite and aid in the disposition. Presiding officer may adopt the need for the procedure for the submission of the evidence in written form, examine the witness and of the hearing, convey, recess, adjourn, otherwise regulate with the course of the hearing, take any other action authorized consistent with the provision with this part permitted by law with the may expedite with the hearing, aid with the disposition of the proceeding continued. Revocation certification 24307. The hearing parties may appear on number one on own behalf through designated representative of the other testimony. Examine the witness record. It will be closed unless additional time is allowed with the submission. Presiding off the written decision based within 10 days. Railroad has burden of proof. Parties may appear for the be heard, but on their own behalf through designated representative of the parties may other relevant evidence testimony they may conduct with the trial examination. Witnesses may be required full disclosure of relevant fact of the record. Proceed with the conduct collusion hearing and left for the presiding officer for the allow with additional time for submission of information. Such instances of the record should be left with the open discussion for the presiding officer for the grants for the purpose of no later than 10 days after the close of the record of railroad official will the other investigating officers will prepare and sign written decision in the proceeding of the decision shall contain the findings of the facts as well as based further concerning all the material issues of the facts presented on the record be served on the employee rail shall have the burden of proving the local move of the engineer's conduct with not complying with the applicable railroad operating rule practices in part 219. Revocation certification 340 307. Hearing. Collective bargaining agreement hearing satisfies requirements may be consoled with a discretionary hearing. Separate findings may waive the not the right, and he may waive the right to a hearing in writing under shame of the right signed with the other railroad shall revoke only one railroad hearing. Periods of suspension is related towards revocation period of hearing, which is conducted in a manner that conforms procedure with the applicable collective bargaining agreement. It shall be deemed to satisfy with the procedure requirement of the hearing with the make control of the any of the disciplinary other hearing with the rising with the shame of the facts all incident with the railroad official with the other investigating officer shall make separate findings of the revocation required with the 24307. The person may waive the right to hearing provided with the 24307. The waiver that shall be made in writing relevant to the fact with the person knowledge and understanding of these rights if the voluntary surrenders them. Be signed with the person making the waiver of the railroad that rely with the certification of another railroad. The 240, 227, the 229 shall be revoked with the certification during the period of the certification of the railroad acquired with the information with the events if another has been revoked and certification acquired with the determined no means no longer qualification requirement of the preamble of the final rule of the paragraph pages 28, 25, 1 explain with the other railroads be the bound of the termination railroads will be received the notifications of the revocation because of the engineer is obligated to adversely affect its railroads if such reverse of the action of the 24305. Collective bargaining agreement hears and satisfies requirements be consolidated disciplinary hearing separate findings waive the right to hearing writing and understand with the right sign with the other railroad shall revoke only one period of suspension of the credits of the revocation period. The requirement to provide a hearing satisfied with any single railroad holds a hearing with no additional hearing is required prior to the revocation no more than one railroad arising from the same facts. Period of certificate suspension prior to the commencement of the hearing shall be certified towards satisfying any applicable revocation period imposed with accordance with the provision 241-17. Preamble, the interim final rule, the page 1899, to clarify with the certificate suspension employed with the instances whether there is reason to think the certificate shall be revoked with a made conditional, but at the time needed to resolve the situation. Certificate suspension is applicable to the instance if the person is awaiting an investigating hearing with the determining whether the person has violated the FRA of the alcohol drug rules and whether they engage with the operational misconduct in situation in which the person after being evaluated treated with an active substance abuse disorder regarding company disciplinary action preamble states of the rules of the railroads of the option of treating an event with a having safely with a significantly warning initiation be investigating hearing with a possible imposition revocation FRA certification due type stand section company disciplinary actions and revocations. Injures active substance with abuse disorder, conditional certified failure to file with the testing and same with the violation, even the 219-102-101, hold a person out of service of the railroad and for the withdrawal of the conditional certification, whatsoever the 240-307 the hearing of the engineer's request. The AR petition for the reconsideration question how to comply with this rule. The two situation involved with the detection of the alcohol drug use of the preamble in terms of final rule, page 19,000. With the first situation involved with the incident of the which from the engineer with the knowingly substance of the abuse disorder failure to adhere with the condition of the imposed with the return service to that it fails to take and fails to successfully pass and follow up the testing after the being returned to serve the question have them raised about whether the railroad treats it with a revocation suspension revocation decision provision provided in 24307 the hearing before altering a person's certification status of the legislative hearing is required concerning have been expressed about the personal impingement of the EAP confidentiality of the revocation hearing, and an engineer with the active substance abuse disorder can be conditionally certified under the term of the subject person with a periodic following up to testing after they've been returned to surface village of the following testing tantamount violation of the 219-102 of the 101. Consequently, the railroad would require that the under FRA's alcohol drug level of the person out of the covered service. The railroad intended for the withdrawal of the conditional certification must afford the engineers a formalized trial type investigatory hearing procedures provided in the 240-307 the engineer so requests. If the engineer with active substance abuse disorder conditionally certified failure to file, but the testing is some of the violation, either the 219-101 or 102, with the whole personnel for the railroad intent for the withdrawal of the confidential certification holds 307 the engineering of the engineer's requests. Confidential is waived on the circumstantial relief of the treatment. The records would not be required for the second situation involved. The incident of the engineer's motor's vehicle driving history show the evidence of substance abuse with a question whether upon receipt of such data rules requires the engineer certification suspended for the investigative hearing. However, the rule does not require the railroad to suspend a person's certificate under these circumstances with intent 24115 without motor vehicle driving records indicating substance abuse on the highway could be relevant to the person's certification status for the conduct of the EAP with the pedestrian non-investigating hearing officers. Alright, Op 9736 with multiple certification events during the same day of duty. FRA has recently received portions of the survive. I believe we went through these questions already. These are the letters of petitions. Certificate and pilots. The certificate joint operation pilots.